Hi, I'm Las Vegas defense attorney Ryan Alexander. When you're arrested for a DUI, two processes begin at the same time. The first is the criminal court proceeding, which will begin either in a justice court in Clark County or in a municipal court, typically in Henderson or in Las Vegas Municipal Court. At the same time, a second proceeding begins at the DMV. This is a civil proceeding and is completely separate in a lot of ways from the criminal case that's going to proceed in the court. If you have been arrested for a DUI and at the time of your arrest you were asked to do a breathalyzer, or you chose to do a breathalyzer test, and they have determined that your blood alcohol content was over a 0.08, the DMV will automatically suspend your license. At this point, the officer will usually take your license away immediately and give you a form, usually pink, that will say that your license has been suspended and that you have a limited amount of time to appeal that suspension. You have 10 days to find an attorney, and if you choose to appeal it, to notify the DMV that you want to have a hearing. Now, we will contact the DMV for you and set that hearing. They're going to set the hearing out in about a month. Now, you don't have to attend that DMV hearing. Usually it's just the DMV commissioner, the police who stopped and arrested you, and your defense attorney. At that time, they'll present the evidence that they have for the reason that they stopped you and whatever documentation that they have proving up your blood alcohol. The most important factors in the DMV hearing are: why were you stopped and what was your blood alcohol? A lot of the other things that will come into play in the criminal defense case, including the police procedures and whether the field sobriety tests were performed correctly, those tend to fit more with the criminal defense rather than the DMV hearing. The DMV will then decide whether the suspension was justified or whether the proceeding against you will be dismissed. Now, in that 30 days that you're waiting for the DMV hearing, your license will be valid again. But if you lose the DMV hearing, it will be resuspended, and you will get credit for any time that your license was suspended in between your first notice and the request for the hearing. After reviewing your case, I'll tell you whether I think it's worth preparing a DMV defense. There are certain situations where it makes it very difficult to win a DMV proceeding. That said, there are occasions when a prepared DMV defense is successful even with bad facts. If you have been stopped and chose a blood test instead of a breathalyzer test, the process will work the same, only it will take much longer because the blood result has to come back from the lab that's going to examine your blood sample, and that will usually take 3 to 5 months to return. In the meantime, you must keep the DMV and your defense attorney up to date on where you are living, because they're going to send you the notice of suspension. And if you haven't told them that you've moved, and right now in Las Vegas a lot of people are changing residence, either they're moving out of their house or they're buying a house or moving out. Either way, if you move, make sure you tell the DMV, because they're going to send that to your last known address. And the consequences of getting caught without your license, even if you didn't know it was suspended, it's a very steep penalty. So make sure you've told your attorney and you've told the DMV and you've told the court where you are if you're moving around. Now, after the blood test is received, you'll receive a notice. If it's over 0.08, you'll receive a notice in the mail again that your license is going to be suspended. From there, the process is the same. We have 10 days to submit a request for a hearing to the DMV. Pending the hearing, your license is still good. Depending on what happens at the hearing, your license may be resuspended or the process against you will be dismissed and your license will be valid. If you choose not to appeal, or the DMV then decides against you that your suspension was justified, you're going to have to wait 45 days before you can get a temporary license. That will enable you to drive to work, school, and any other essential activities, but it will have a curfew imposed. After 45 days more, 90 days total, you can get your full license reinstated. In order to get your full license back, you're probably going to have to send the DMV an SR-22 insurance declaration. This is a form that your insurance company sends to the DMV that says that you have the appropriate insurance coverage. Note that you're still going to have to get an SR-22 if you have a deal where your charge of DUI is amended down to a reckless or a careless. The court will still require, and the DMV will still require, the SR-22 declaration. And that will last for 3 years. Talk to your insurance agent for more information on the SR-22. If you've been arrested for a DUI, call me, Attorney Ryan Alexander, at 868-3311. And I'll go over the specific facts of your case and give you a free consultation with more explanation about how the DUI process works in Clark County.